His 6-3 Supreme Court decision blew up the old gun law playbook, and states started rewriting carry rules almost overnight. Pause. If you still think your permit means what it used to mean, you could walk into the wrong place tomorrow and learn the hard way that the rules changed before you did. Quick question before we continue. Are you subscribed? Because what I'm about to break down could help you avoid a life-changing mistake. Hit that button right now, because most gun owners do not read court opinions, they do not track emergency rule changes, and they usually find out after a stop, after an arrest, or after a prosecutor says, "You should have known." And I don't want that to be you. So stay with me, because this story is not just about one case. It's about what happened after that case, what changed fast, what did not change at all, and the part almost nobody explains clearly. Here's what just happened, or more accurately, here's the ruling that set this whole legal wildfire in motion. In New York, State Rifle and Pistol Association against Bruen, the Supreme Court ruled 6-3 that New York could not force an ordinary law-abiding person to prove some special need before carrying a handgun in public for self-defense. That was the old proper cause rule. In plain English, the state was saying, it is not enough that you want to protect yourself. You need a special reason beyond the average person. The court said no. That rule violated the Second Amendment as applied through the 14th Amendment. Now, this is where it gets interesting. The court did not just strike one New York rule. It also changed the way judges were supposed to look at gun cases. Before Bruen, many lower courts used a two-step method. First, they asked if the conduct was covered by the Second Amendment. Then they often asked whether the law seemed reasonable enough to survive. That second part was basically a balancing test. Bruen rejected that approach. The court said if the text of the Second Amendment covers the conduct, then the government has to show the law fits with this nation's historical tradition of firearm regulation. That sounds technical, but here is the simple version. Judges were told to stop saying, "This law feels like a good idea," and start asking, "Do we have a strong history of laws like this?" That is why people call this ruling a firebomb. It did not just knock over one law, it changed the legal map for challenges all over the country. Suddenly, states with tough carry rules had a problem. Courts had a new test, lawyers had a new weapon, and regular gun owners had a lot of new confusion. But here's the crazy part. A lot of people heard Bruen and thought it meant open season, no permits, carry anywhere, game over for gun laws. That is not what Bruen said. The court did not say every carry restriction is dead. It did not say permits are unconstitutional. It did not say you can carry in every building, every train station, every school zone, or every private business. And that misunderstanding is where people get burned. First thing you need to know, Bruen protected public carry for ordinary self-defense more strongly than before. Second thing, Bruen also triggered a wave of state countermoves. Some states loosened up, others rewrote their laws fast and tried to list more so-called sensitive places where guns could still be banned. Third thing, and this is the part nobody's talking about enough, your biggest danger may not be the law you think is unfair. It may be the law you assume disappeared, when it actually did not. If you're finding this helpful, imagine what you'll learn in my next video about the exact words to use if an officer asks whether you're carrying during a traffic stop. Subscribe so you don't miss it, because knowing the law is good, but knowing how to handle the moment when the law meets real life is even better. Let me break this down for you in the real world. After Bruen, several states did not just sit there. They rewrote carry laws almost immediately. They expanded training rules, changed application rules, and created long lists of places where carrying was still restricted. New York's post-Bruen law became one of the biggest flashpoints. It tried to ban carry in many sensitive locations, and even treated many private properties as off-limits unless the owner clearly allowed carry. That led to more lawsuits, more confusion, and more people thinking the Supreme Court would swoop in right away and clean it all up. But that is not how this usually works. Supreme Court rulings can feel instant on TV, but on the ground, the cleanup is messy. Lower courts still have to apply the new test. States keep defending their laws. Different judges reach different results. And while all that fighting happens, you are the one driving to work, walking into stores, parking near government buildings, and trying not to guess wrong. Here's a hypothetical example to explain this. Imagine you got your carry permit years ago. You follow the news a little and you hear, the Supreme Court struck down New York's carry law. So you think, great, I'm covered. Then one morning you stop for coffee, step into a posted private business, and later head into a place your state now treats as restricted. You still have your firearm. You still think you are the good guy. But now you may be standing in a location the state says is off limits under a newer rule. That is how ordinary people fall into extraordinary legal trouble. Most people think the biggest risk is carrying without a permit. But the truth is, in some states, the bigger risk is carrying into the wrong place with a permit. That is a huge difference. And if you do not understand that difference, you can make a bad decision while believing you are fully legal. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. And here's another part many people miss. In April 2025, the Supreme Court declined to hear a challenge to parts of New York's newer gun restrictions. That does not mean the justices approved every part of that law forever. It means the court did not take that case at that moment, which left the lower court ruling in place for now. That kind of move matters because people often hear Bruen and assume every later restriction automatically falls. No, some survive, some get narrowed, some stay in effect while litigation drags on, and that means your state law today may still be very different from what your buddy in another state is dealing with. So here's what most people get wrong. They think one big Supreme Court win wipes out the whole anti-gun rulebook. But the truth is messier. One ruling can expand rights and still leave huge gray zones. One ruling can help gun owners and still leave you exposed if you rely on headlines instead of current state law. Don't make that mistake. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who come here to get the full story before the headlines twist it, oversell it, or bury the fine print. Click subscribe and stay one step ahead. Now let's talk about the part that shocked me most. After Bruen, a lot of people expected the Supreme Court to keep moving in only one direction. More rights, fewer restrictions, one straight line. But that is not what happened. The court's later gun cases showed something much more important. The justices are not saying every gun law fails. They are saying the government has to justify laws the right way, and sometimes the government still wins. Fourth thing you need to know. In United States against Rahimi, the court ruled 8-1 that a person found by a court to pose a credible threat to another person's physical safety can be temporarily disarmed. In simple terms, if there's a valid domestic violence restraining order with the right findings behind it, the government can still take that person out of the armed category for a time. So if somebody told you Bruen means all prohibited person laws are dead, that is just false. Let me explain why that matters to you. Because it shows the Supreme Court is not treating the Second Amendment like a magic shield against every restriction. The court is still looking at history, tradition, and the kind of danger a law is aimed at. So if you are trying to understand what comes next, do not think in slogans. Think in categories. Who is restricted? Why? For how long? Based on what finding? Those questions matter. Fifth, bump stocks. In Garland against Cargill, the Supreme Court ruled 6-3 that the federal government had gone beyond what the existing machine gun statute allowed when it tried to classify bump stocks as machine guns through agency rulemaking. That does not mean every bump stock is now legal everywhere. Read that again in your mind. It means the federal agency could not stretch that specific statute that far. Congress could still pass a different law. States can still have their own bans. So if you hear somebody say, the Supreme Court legalized bump stocks nationwide, that is sloppy, and sloppy can get people arrested. Sixth, ghost guns. In Bondi against VanDerStok, the court ruled 7-2 that the federal rule covering at least some gun kits and unfinished frames or receivers was not facially invalid under the Gun Control Act. In normal English, the government can regulate certain build kits and unfinished parts when they can be readily turned into working guns. So once again, if someone tries to tell you there was one giant overnight win for every gun-related product, that is not true either. But wait, there's something even more important. These cases, taken together, tell you how to think. Bruen was the firebomb because it changed the test. Rahimi showed not every restriction fails under that test. Cargill showed agencies cannot just rewrite statutes because they want a tougher policy. VanDerStok showed the government can still regulate some products if the statute actually reaches them. That is the real lesson. So what should you do with all of this? First, stop relying on viral posts. Second, check your own state law, not just federal headlines. Third, pay close attention to location rules, not just permit rules. Fourth, never assume a Supreme Court case erased every lower law around it. And fifth, if your case is specific, weird, or high risk, get a real attorney in your state before you make a move that could cost you your rights. Laws move fast, and one new ruling can flip the practical rules long before most people even hear about it. Subscribe now, because the next video breaks down the exact steps smart gun owners should take the moment their state changes a carry rule, adds a restricted place, or rewrites permit language. So here's the bottom line. That 6-3 Supreme Court decision did blow up the old way gun cases were judged, and it changed the carry law fight across America almost overnight. But it did not create a free-for-all. Some laws fell, some survived, and some are still hanging in the balance, while regular people like you are left to sort through the mess. If this helped you see the difference between a headline and the real legal risk, subscribe right now and share this with one gun owner you care about. Seriously. One friend, one family member, one person who still thinks I saw a post about it counts as legal research. And final simple disclaimer, I'm giving you general educational information. not advice for your exact case. Laws change, states differ, and if your freedom is on the line, talk to a licensed attorney before you act.